state here, all persons having business with the appellate are here, give your attendance, and you shall be heard. Please be seated.
Good afternoon. Welcome to the Appellate Division First Department. As I call the calendar today, please tell me the time that you actually need. And remember that the panel has if we have additional questions, past the time you've been allotted, we'll ask them and you'll have an opportunity to answer. We've read your papers and are familiar with your arguments. For those of you here for the first time, you should know that the white light on the lectern will go off when you have 2 minutes left, or if you've asked for less than 2 minutes, it will go on immediately. When I call your case, rise and let me know how much time you are requesting and who you represent. People v. Daniel Sittalon. Who are you here for?
3 minutes for the people.
Defendant? No? Okay. 3 minutes. Yeah. I'm sorry?
He stood back up again.
If there's no one here for people are.
Okay, we'll take it on submission. Juan v. Wendy is submitted. Engley v. 639 Jefferson Place and Engley v. City of New York will be heard together.
Defendant appellant for Sertina Robinson. I request 10 minutes on that one, and then on the other one, defendant responding.
Yeah.
So I would also take 5 minutes.
And you're here for the city?
For the city, we request 4 minutes, Your Honor.
Okay. So I worked out the choreography this way. Why don't we start with Robinson with 5 minutes, and then go to the city, and then go to you, and then go to Robinson again for another 5 minutes, because you'll need to respond to the plaintiff, and then give the plaintiff the last word with 2 minutes. Does that make sense? So you get 5 and 5, counsel, because you got an appeal and he's got an appeal, and he gets 5 and 2, which is somewhat less than you, since you have to respond to 2 arguments, and the city you get 4. Okay, very well. You can be seated. People v. Jaden Decabert. Submitted. Amatec v. Goldfarb. 8 and 2 and 8. LS Children. Anybody here on LS Children? Submitted. People versus Charles Cañada. 6 and 2 and 6. People versus Anthony Messina. Eight and 2 and 8. Tavares v. 920 East 173rd Street. Submitted. Asantino v. City of New York. Submitted. First case up is People versus Daniel Sittalon.
I thought that was submitted.
Oh, well, he submitted, that's right. Pardon me. So we'll start with Engley.
But it was nice of you.
Robinson, you go first.
Good afternoon, Your Honors. Okay, so this is our appeal for Sertina Robinson. We're appealing the decision of the lower court, Bronx Supreme, granting city's motion for summary judgment, dismissing plaintiff's complaint against them. This is a premises liability case. The plaintiff was walking past 2 adjacent properties.
Yeah, we're pretty familiar with the facts.
Okay, Your Honor.
Is there any evidence that shows any special use by the city or that they engaged in any affirmative act that resulted immediately in a dangerous condition?
Okay, well, Your Honor, in our opposition to the city's motion, we had submitted Google Earth images which showed that the tree well back in 2007 existed as a 5x5 tree pit as per the DOT regulations. Sometime before 2011, they modified that tree well and extended it out about 2 feet into the adjacent sidewalk flag.
Right, and your theory is, I gather, that you think that some of the underlying roots caused the misalignment of the blocks.
Your Honor, not just the roots, but the work itself raised the slab.
Does the work have to result in an immediate dangerous condition, or could it be, as you said, over a 5-year period?
Well, I would say either or. Well, there was just something I wanted to add. I'm sorry, Your Honor. You're asking about the work itself. You know, our client who owned the property never had an issue. They never received any complaints. There was never any complaint of condition regarding the sidewalk. But our contention is that the work did immediately raise the sidewalk and create a height differential.
You said that it immediately created the height differential?
Well, to be honest, it's hard to say. It could be either or, but the bottom line is we're saying that the work did cause that height differential.
And other than the photographs, what else did you submit to establish that point?
Okay, Your Honor, another thing is the city produced for deposition somebody from the DOT, which had no knowledge of tree wells or tree pits. They said you would have to depose somebody from the New York City Departments of Parks and Recs. So we served a deposition notice on the city to produce a witness from New York City Department of Parks and Recreation. They never produced that witness, nor did they produce any documents or permits regarding the work at that location for the tree well.
So your position is that the city didn't meet their burden because in opposition you only submitted, an attorney's affirmation, pictures, and general rules. There wasn't anything else.
No, Your Honor, but the lower court actually erred. They shifted the burden onto us to prove that the city created the condition when in fact it was the city's burden all along to prove they hadn't created the condition. So we raised the tribal issue of fact. And in addition, they planted the trees too close together. This is all in violation of the DOT rules. So that the roots themselves also could have contributed to the raised sidewalk, all raising a tribal issue of fact. So therefore, they shouldn't have been let out.
So are you conceding that the city made out its prima facie case for summary judgment?
I would say that no, they didn't, Your Honor, because their motion was all conclusory statements.
They did show that they didn't have any prior written notice. Isn't that the sum total of their burden initially? And then the burden, I believe, shifts to you. Correct me if I'm wrong, to show that there was some special use or there was, they created the condition.
Well, Your Honor, I would say that the burden lies with them to show that they didn't create the condition. I mean, in this case, we're talking Administrative Code 7-2.
201C2, yeah.
Right, so it falls under an exception because we're arguing since the city did do this work and modify the sidewalk in that way, that the code doesn't apply and doesn't import liability onto us, the landowner. The cities should be liable in this case.
You can finish the thought.
Okay, Your Honor. The city's arguments were completely conclusory. They said they had no prior written notice, and they said they didn't create the defect. In their reply papers, they didn't even address the tree well. They didn't include documents from the New York City Departments of Rec. So therefore, it was conclusory in nature. The lower court erred in their decision, and we wish for the appellate court to reverse and deny the city's motion for summary judgment.
Thank you, counsel. You have time to rebuttal.
Thank you, Your Honors.
May it please the court, Jeff Kerfman, on behalf of the City of New York, Supreme Court properly granted summary judgment to the city, and this court should affirm.
So how did the city meet its prima facie burden?
In two ways, Your Honor. Number one, the city met its prima facie burden of showing that it didn't have prior written notice of a defect by submitting records showing that there were no permits or other documents demonstrating work in the 2 years prior to the accident. And second of all, it met its burden under 7210 of showing that the accident occurred on a sidewalk that was non-exempt. It was a non-exempt property, as the appellants do not dispute here. And in either case,
There's
the
no
burden.
dispute that Ms. Robinson did not live in the building, correct?
That's correct, Your Honor. They don't dispute that this was a commercial non-exempt property, and the burden therefore shifted to them, contrary
What
to
about the aspect of perhaps having created the defect by planting the trees too close together?
Your Honor, their only theory on this point, a couple points. Number one, they haven't presented evidence showing, as was their burden, that the trees were planted too close together. They rely on speculation, pointing to photographs. They didn't take any of their own measurements. But secondarily, even if the trees were planted too close together, their entire theory is that for that reason, the roots of the trees somehow elevated the sidewalk flag. And as the Second Department explained in Gallus, that's not a basis for liability against the city under Section 7210. And appellants don't even mention that case, let alone explain why it was decided incorrectly in their briefing.
If the allegation was that the city created the defect, would the defect have had to have arose immediately for liability to attach?
So for purposes of prior written notice, that is the standard as the Court of Appeals articulated in Yarborough. And as I emphasized, the city did meet its prima facie burden of showing that it lacked prior written notice. So for that prong of the test, it was appellant's burden to show that any action by the city would have immediately created the defect. They failed to carry that burden here. The court has no further questions. We would ask that you affirm.
Thank you, counsel. No, you're up next, sir. Yeah. It's a little complicated because there are two entwined appeals.
May it please the court, Jason Steinberg representing Mr. Engley. Obviously, it's our position that the court engaged in issue determination in this case to deny my motion for summary judgment. And we established prima
The
facie.
photos look, Justice Danziger seemed to go that the misleveling went right between the two properties.
Well, it's not right between the two properties. If you look at the photograph, this is plaintiff's exhibit 1. I actually have the photo here. Let me just get the right record page for you.
We probably won't be able to see it, counsel. It's all right.
Right. Record 174, the sidewalk flags, there are 3 of them abutting right at the front door of the property, and the defense witness admitted that that's his property.
In your in the record, is there any indication that Robinson took ownership of the raised flag?
Yes, in their brief, they actually say that when they argued that there's an issue of fact, they're saying that we had to prove that the defect wasn't caused by the raised flag on their sidewalk or the depressed sidewalk on the neighbor's flag. There's no such burden in any case law in the state of New York that requires a plaintiff to prove how a defect was caused, insofar as 7-210 requires an owner to maintain the property sidewalk in a safe condition and to correct any defect that's a ½ inch or more. In this case, we have an 1.5 inch defect on a sidewalk flag on their property. I don't have to prove that it was caused, the raise was caused by their inaction or action, or that it was the neighbor's depression, so long as the defect is on their property. And then, of course, the common law burden if they have actual or constructive notice of the defect and fail to repair it. And in this case, the constructive notice is established through the photographs, which show that an elevated sidewalk flag of 1.5 inches, which is measured, confirmed by my client, and a photograph taken just after the accident before the notice of claim was filed. He said it was a fair and accurate depiction of how the sidewalk appeared at the time of the accident. He said it was about 2 inches. It's 1.5 inches per measurements. There's weeds growing in the sidewalk. That doesn't happen overnight. So this is the type of elevation that does not happen overnight. And the witnesses for the defendant, yeah, I manage it for my wife, but I don't remember if I've ever been there before. You have a burden to do reasonable inspections of your property. That's well established in both this department and the second department to uncover defects. You can't turn a blind eye to defects that exist on your property and then say, we had no knowledge of it. If you're not doing inspections, that's on you. It's a constructive notice case. I can't say actual notice because the witness says, I don't remember ever being there, so I couldn't affirmatively establish that. However, there's sufficient evidence under the case Tropper, first department case. If my client is able to provide a measurement based upon his observations, together with photographs taken shortly after the accident to show constructive notice, that's my prima facie burden. Their argument, sole argument in opposition, was not we didn't own the sidewalk. Their opposition was, well, he didn't show that it was caused by a depression as opposed to an elevation. That's completely irrelevant. And Justice Danziger's holding that we didn't have a survey is a heightened burden that's not required under the law if the ownership of the property is undisputed, which is what the case is here. And you have a question?
Yes, I have a question about the photographs. Is there, in the photographs around the part where you indicated we should look, there's nothing showing that the 1.5-inch elevation is actually 1.5 inches. There's just a part of the photograph that's kind of dark.
That's one angle of the photograph. The one I showed you was just to show that it was in front of
Right.
700 Pugsley. If you look at the front door, 700 Pugsley is right where the elevation is. My client identified the elevation in this 174.
But there's nothing in the photographs that, there's no photograph that has a ruler next to the
There's another
alleged-
photograph.
sorry?
There's another photograph in the record with the measurement and the measuring tape showing it's 1.5 inches. And my client also testified at his deposition that it was a fair and accurate depiction of how the sidewalk appeared. There is another photo. I can get the record page for you, but it's definitely in there.
Okay.
So that does exist. So I was referring to that photograph to show that it's in front of the property that their client admitted was his property. That front door is mine. So there's enough in there that Judge Dandiger shouldn't have had to say, you need a survey. Nobody argued that. The defendant did not argue that. They conceded ownership. It's admitted in their answer that it's their property. The witness testified. His wife owns it. That's not a dispute. And he's also saying, well, the city caused it from tree roads. Why would he say that if he didn't own the property? It would defeat the whole argument. So if the court has any other questions.
Thank you, counsel.
All right, thank you.
We'll go back to Robinson now. You've got another 5, counsel, so take your time.
Okay, Your Honor. May it please the court, my name is John Calabro from the Gold Law Firm for Satina Robinson in opposition of plaintiff's appeal. First off, we raised multiple tribal issues of fact here. First off, plaintiff didn't submit a survey as to who owned the property. As we all know, property lines don't always run right down the seam of a sidewalk.
Counsel, in your opposition papers below, did you assert that any ownership, or rather did you say that the flag was on your side, but the depression is what's actually the problem on the other side of the property, on the other property rather?
Well, Your Honor, we made an argument as to causation of plaintiff's trip and fall. You don't know whether it's the neighboring flag is depressed or the flag in front of our insured's property is raised, because also plaintiff never submitted an expert report. Because if our sidewalk flag is even with the curb, that means our sidewalk is good and at the correct height. Therefore, we would bear no liability, and that would show that neighboring properties.
Counsel, I'm sorry, maybe I misunderstood your argument. He's saying that if it's okay at the curb, it doesn't matter that it angles up 4 inches, misleveling later in the sidewalk or closer to the buildings?
Well, Your Honor, we're arguing that from the photos and also the testimony from the plaintiff at his deposition, you don't know whether or not it was caused by a depressed flag or a raised flag. So I'm saying that if our flag was even with the curb.
Plaintiff indicated that they tripped over a raised flag.
That he tripped over a height differential. So we're saying that you don't know if that flag was raised or the adjacent flag was depressed.
But what was actually testified to as the cause of the accident was the tripping over the raised flag.
Well, Your Honor, the plaintiff testified that he tripped over, in his words, I guess he may have said a raised flag, but he's a lay witness. He doesn't know whether or not he knows he tripped over a height differential. He doesn't know whether he tripped over a flag that was raised or because one was depressed.
But did you contest before the motion court which side of the property you owned? Was that raised?
No, we did not. But in this case, the plaintiff, there's no way to tell without a survey who ultimately owns the property.
Well, did you admit in your answer that you owned the property on which the plaintiff alleged he fell?
Well, Your Honor, we admit ownership to the premises, but not the sidewalk. We don't own the sidewalk. We know a landowner is responsible to maintain the sidewalk, but we don't.
That abuts the premises.
That abuts the premises. We own the premises, but not the sidewalk.
And so let's assume that plaintiff's testimony was enough to make out the prima facie showing. What did you put in to raise a triable issue of fact?
Well, what we're stuck with is only plaintiff's testimony. There's no witnesses. There's nothing else. So the credibility of the plaintiff as a witness at trial should be left to a jury.
So plaintiff testifies, I fell on a raised sidewalk flag. Now, you could put in evidence, maybe not of a fact witness, but maybe an expert who inspects the competing sidewalk flags and says, the flag on my premises was in a reasonably safe condition. It was the flag on the other premises that was problematic. Could have defeated it in that way, at least defeated summary judgment in that way, right?
Possibly, Your Honor, but the fact that plaintiff didn't hire an expert, didn't include an expert in their motion.
Is an expert needed if we have the plaintiff's testimony about where, in fact, the plaintiff fell?
Well, Your Honor, the location of the fall is one thing, but the cause of it is another. See, now, without an expert, you don't know which sidewalk flag was raised or depressed, because you have to go off that measurement of the curb. If the sidewalk is level with the curb, which is also a DOT regulation, that the surface of the sidewalk be level with the curb to be in accordance.
Well, the defendant has a duty not to create a hazardous condition on their property. But then wouldn't they also have a duty, a further duty, to, in the exercise of reasonable care, remedy any hazards on their property, not that they caused, but existed on their property, for a sufficient period of time for the defendant to reasonably perceive the defect and correct it?
They do, Your Honor, but again, we're arguing that we had no notice of any defects. There was never any complaints regarding the sidewalk, never any issues prior to this. So that was that in that regard.
But the defendants never went to the property, so what kind of notice would we expect them to have of a defect that they never actually went to the property?
Well, the husband of of the owner, Sertina Robinson, her husband was almost like a property manager. He would visit the property and he never saw anything wrong with it. He would check it, make sure things are okay. He never observed any problems regarding the sidewalk or anything else with the property. Never received complaints. There was never any other trip and falls prior to this.
Thank you. Any other questions? Thank you, counsel.
Thank you.
Plaintiff, you've got 2 minutes more.
A couple of things. They did not argue notice in lower court. That wasn't their argument. The argument, again, was causation. That it was, we don't know if it was a depressed flag versus a raised flag, which is incorrect. That's number one. We don't need an expert to establish a height differential. Tropper specifically held that. And this court said, if we have photographs and we have sufficient evidence from the plaintiff that's undisputed, that's sufficient prima facie. So I just want to address those 2 points. And that's it. Thank you very much.
Thank you, counsel. Thank you all.
Thank you.
Emitech v. Goldfarb.
May it please the court, Mark Zauderer for the appellant. I'm going to address two of the most important issues, the summary judgment issue and then the tax issue, and I respectfully submit on both the court got confused and applied the wrong standards here. In fact, I think the record reflects, and we discussed in our brief, that the court made findings of credibility, and one, for example, it reached the conclusion that Mr. Goldfarb attempted to hold up the EPA mandated work simply because he did not want to pay for it. I mean, that's the kind of thing that should have been subject
Did he
to
have the
trial.
power to hold up the work, though, if it was mandated by the EPA?
That's not the issue, respectfully. We disputed whether the work was mandated, but whether or not it was mandated, that is separate and apart from the obligation to recognize Mr. Goldfarb's right as a co-manager. In other words, he had a right to participate in the negotiations with the EPA, and I think that got lost below.
Sir, could you walk us through what under the contractual documents were the rights of co-management that your client enjoyed?
I'm sorry, what was the question?
Could you just walk us through the rights attendant to co-management that your client enjoyed?
Yes. This is based on the fact that in November of 2020, it's in the record, they objected to some of the work. They wanted to participate.
What
They said
contractual provisions lay out the nature of the co-management?
the contractual provision is in the record at page 566. It says management of remedial work. And it says the company or its designee and Stephen Goldfarb or his designee shall have the right to co-manage all activities related to and in furtherance of the record of decision of the West Side, et cetera, and the related consent decree, as well as any future remedial work for which the company may be liable or responsible at the EMOU. That's one of the sites.
And further down in that, that's, I think, I believe, section 4.1 that you read from, but further down in section 4.5, where it talks about the right to monitor work, to participate, and to be kept informed.
Yes.
It would seem to me that based upon the email chain that we have here, that was met. He was informed, and in fact, in the email chain, there was indication that Mr. Goldfarb did not want to pay for certain things, going so far as to say before the EPA gets angry and things of that nature. How are we reading?
Yes, Your Honor. The email in November said, I'm not going to pay until we have the opportunity, in essence, to participate. This was during COVID, by the way. And they reiterated that until April of 2021, when the work had been done, when the record shows that Mr. Goldfarb was told for the first time that their objections were being rejected by Amatec. And they had said in response, it's in the record, the email in April, rather in November, they said to him, we'll get back to you. They never got back to him. And that is supported by the affidavit of, rather the deposition testimony of Mr. Schmidt, who confirmed that that was when in April they told them about it. And he admitted in the affidavit, in the testimony, that he had been complaining since 2020. So it's all in the record.
December 18, 2020, Schmidt sent Goldfarb another email, right? And he said, this is what the EPA wants us to do with respect to CAP4. Wasn't that a heads up about the work that was coming?
Which date? I'm sorry, I don't have.
It was an email from December 18, 2020, I believe.
Yeah.
Schmidt forwarded to Goldfarb an email he received, that Schmidt had received from the EPA concerning what was going to happen in CAP 4. And I thought that that was a heads up, or it seemed like that they're arguing that that was a heads up to Goldfarb about what was coming, what was mandated, again, returning to that.
But he wanted to participate in that discussion, and he was denied the opportunity, and that was the basic breach of their right to co-manage. It's not the issue, as we said before, of whether the work was mandated. There had been a long record. They paid millions of dollars, after this process to the EPA. They negotiated, because they had no direct standing, so the only way they could be heard and have their rights vindicated in the indemnification agreement was to participate, and that's what they were denied.
Was there anything in the agreement that said that Goldfarb had the rights to communicate directly with the EPA?
No. In fact, that's exactly why we're focused on the breach of Amatec in not permitting them with Amatec to meet or to be involved in the day-to-day discussions. So what the
Do they have that right to meet and be involved?
they
in
had the
day-
right to co-manage that
Right,
process.
but the level of co-management on something that's mandated, is it not satisfied by them getting all of the information about what's necessary,
No,
what's
that's the
needed?
cart before the horse, because it's what the process, it takes place in the discussions with the EPA to determine or to lead to the EPA determining what's mandated. That's the process, so they have it backwards. I'd like to get, my time is so limited, two points. The judge got confused here and applied what trial lawyers call the red light, green light rule. So you had the assertions that should not have been discarded from Mr. Goldfarb, and the judge said, well, there's contradictory evidence. Well, the red light, green light rule, which is familiar to us, is that if a witness
Excuse me, I think
testifies...
that to the extent that he said that they were contradicted, it was not by another person's statement, but by documentary evidence regarding specific things. That's a very different basis for denying summary judgment than if it was just one person's word against another. But the documents underlying it, which affected everybody, certainly the court could take into consideration in deciding summary judgment if there was a real issue of fact.
These were not documents that were self-explanatory, that were clear on the face. They were plans, and what the affidavit of Mr. Goldfarb says, these were plans, things they planned to do. This is the kind of document that was routinely submitted. You had going on at the same time the objection that Mr. Goldfarb had to agreeing to anything until they had the opportunity to participate. And that was where the breach occurred. In fact, another issue they raised, I want to, if I may, get to the tax issue, because that's a...
Counsel, we have a wealth of time, so go ahead. I'll give you another couple minutes, actually.
Thank you so much. The tax issue is totally confused, and it was a multi-million-dollar issue. Okay, there were two different provisions in the indemnity agreement.
Counsel, with respect to the tax issue, Amatec said that it explained its methodology to you in 2010, and that the methodology had been what it was throughout the life of the agreement. And so it was not a surprise about how they were calculating the amounts owed by Amatec.
This question
Owed by your client, pardon.
comes from the confusion that the trial court created. There were two different provisions, entirely different. One is where the tax issue applies. It says in the document that when you are being asked to pay for a certain item of indemnification, you take into account the tax issue. So it's reduced. That is the tax savings to Amatec as a result of the business deduction. Right?
Wait, but that's a big question, whether you're talking about the tax savings to Amatec or whether you're talking about the expenditure by your client.
No, we're conflating two issues. There's no disagreement that the tax issue, the tax has to be deducted to determine the amount that has to be indemnified by the Goldfarbs. Now, we said we wanted discovery on that, okay. But the other issue is, well, how do you determine the cap? And that's a multi-million-dollar issue. And there, when you look at the definition in both cases of losses, in the case of the cap, you do not deduct the taxes and the tax savings. And the court completely got that wrong. Under their view, under the court's view, let's say it would have to be $43 million indemnification before the $30 million would be reached if you took into account the tax savings. There is no tax saving provision. It's omitted in the document. And
So are you saying that the amount of indemnification should include whatever taxes there were?
Both parties agree in the briefs that, let's say, $10 million is paid, would be if $10 million was spent on the remediation. But Amatec would get a tax saving when it paid the $10 million. So the Goldfarbs would only be liable for, say, $6 million. That's not in dispute.
Okay.
But the court got confused because it dealt with what's called the cap and determined and conflated the two issues and said, well, you don't exclude the tax considerations, or rather you do it. And that's wrong. The court
You
said,
got some extra time already. You can,
let me-
on rebuttal, you can make the point. That
all right,
Thank you.
thank you.
Okay, we'll hear from Amatec. Counsel, I'll give you another 2 minutes as well, just to even it out, if you need it.
So I'll also start with why summary judgment should be affirmed and then move to what my
Can you speak to the co-management aspect of this and giving Goldfarb an opportunity to participate in the discussion as to whether the contract called for just that, the opportunity to participate in the discussion?
Yeah, Section 4.5 of the contract addresses this directly, and I think your question before was referring to it. It gives Mr. Goldfarb the right to, on his own behalf and as a representative of the sellers, to, with respect to the EMU, to communicate directly with the U.S. EPA or other government entities after giving notice to the other party. And also,
They couldn't participate in the dispute resolution that was specified in the consent decree, could they?
the dispute resolution as between the EPA and Amatec under the consent decree, that's right. They could not be a direct party to that. But that is not what they're asking to be able to do. What the Goldfarbs are now saying that they wanted to be able to do was to meet with the EPA to be able to object to work before it became mandated or to object to the scope. It's not entirely clear. That is something that Mr. Goldfarb was always able to do and always had the right to do with Amatec or without Amatec, but he declined to do so. Another thing that Mr. Goldfarb also always had the right to do.
What do we have in the record to support that there was a declination to do that?
Well, it didn't happen. There was an email from Mr. Goldfarb in November of 2020 stating that he was not going to authorize any further work.
And there were other emails indicating that that he wanted to he did want to reach out to the EPA before they got angry.
Yes, right. There were several sets of mixed messages here. There was the email in November 2020 from Mr. Goldfarb saying that he was not going to authorize any future work. That was shortly followed by, in January of 2021, Mr. Goldfarb approving invoices for further work. And then in February of 2021, approving even more invoices for further work. And there was no further statement from Mr. Goldfarb either demanding to speak with the EPA or invoking dispute resolution.
Counsel, defendants say that your own experts and agents agreed that the EPA's request for this work was perhaps counterproductive in that it wouldn't ameliorate leakage from other wells or other polluting sources. And so therefore, why didn't your client take the lead and try to renegotiate what the EPA wanted you to do?
Amatec did do so. The record reflects that Amatec expressed those very same concerns to the EPA. And the EPA sometimes was persuaded with respect to some of the scope of work for some of the caps, but for the most part was not. The EPA took the position that it is the obligation of those who are under the consent decree to clean up the site and to remediate it when it is out of compliance, which is what it was. And so the EPA ordered Amatec to go forward with the compliance action plans that it also ordered Amatec to prepare.
Counsel, I'd like you to address the statement made by counsel that the motion court improperly made credibility determinations in deciding the motion for summary judgment.
Right. The motion court did not have to make any improper credibility determinations. Nothing requires a motion court to find a disputed issue of material fact when an affidavit is obviously untrue on its face. And all the court needed to do was look at the record to see that the statements in the affidavit that Mr. Goldfarb says he was unaware of the work going forward simply couldn't possibly be true. And this court can do it as well. You can look at the record and you can see all of the emails and all of the transmittals with Mr. Goldfarb's name right on the to or the CC line transmitting the budgets, transmitting the approved cap plans, transmitting the directives from the EPA to go forward with work.
He said he didn't know about ERP 23. What about that?
That was the cap 3 well, was ERP 23. It's not clear what exactly he's saying he didn't know about. I think what he's saying he didn't know about was the plan to go forward with it despite his objection to it. Not the plan to go forward with it, not the nature of the work.
So therefore, that doesn't create an issue of triable fact, since we don't know exactly what he was not informed about and what he would have done?
No, because it's legally immaterial. Whether he knew about it or whether he agreed with it or not really has nothing to do with whether he has an obligation to indemnify the work, because it was mandated by the EPA. That's what Section 4.2 of the contract establishes, that if work is mandated by the EPA, then it automatically must become part of the approved budget. AMETEK has an obligation under the contract to carry out the work, and it has an obligation under the consent decree with the EPA to carry out the work. So once work is mandated, it's not like AMETEK can just decline to do it to appease the Goldfarbs. It has to go forward. And
What were the contours of the Goldfarb's contractual right to co-manage?
They are explicitly set out in the agreement. They include the right to observe the work. They include the right to be informed about the work. And under Section 4.5, it includes the right to speak directly with the EPA about the work.
And as to,
I think we're going to ask the same question.
as to elements 1 and 2 of the list you just provided, has there been a showing as a matter of law that they were afforded those 2 rights?
Yes, that's what the motion court found. That, yep.
I'm interested in what your view is on that and
Right,
how you,
yeah.
discharge that burden.
Sure, yes. This could be determined as a matter of law based upon the undisputed record before the motion court. There is a mountain of evidence in the record of documents that were transmitted to Mr. Goldfarb with all of the information that he would have required to be able to exercise his co-management rights. And in fact, he did so, right? There's also evidence in the record that he approved certain of the requests and that he paid certain of the invoices, and then he stopped doing so because he disagreed with them, not because he was unaware of what was happening.
Was there anything in those co-management, I don't want to say duties, but the what he can do as a co-manager that would allow them to stop the work or decline the work or say that they would have the final determination as to whether or not the work would be completed?
Nothing at all. The only thing that Mr. Goldfarb could do if he had a disagreement about the scope of the work was invoke dispute resolution, which he declined to do. And now, of course,
Did both parties enjoy that right to initiate the ADR?
yes. And Mr. Goldfarb accuses AMETEK of breaching that obligation by not invoking alternative dispute resolution. However, it is only Mr. Goldfarb who objected to the work. And if anybody had the obligation to invoke dispute resolution, it would have to be Mr. Goldfarb. And instead of doing that,
They brought suit in California.
yeah, he filed suit in California, breaching the contract's venue provision, but also breaching the dispute resolution provision, just skipping past it entirely. And so, Mr. Goldfarb should not be heard to argue that AMETEK has breached the dispute resolution clause. AMETEK is the only party that actually invoked the dispute resolution clause, and it was rejected. If there's still a little bit more time, I would like to turn to what my colleague characterizes as the tax issue, but I think it might be more clear if we refer to it as the indemnity cap question. The most important thing to know about the indemnity cap question is that this court does not need to decide it right now because it really was not presented in any way below. The $30 million indemnity cap could only be material if there was any contention that the damages on motion for summary judgment would have exceeded the cap, and nobody thinks that that is the case. So how the indemnity cap works.
How much have they paid so far? Roughly 25 mil?
So there's pre-litigation, there's a certain amount that they've paid, and then this amount is $7.5 million or so. And pre-litigation,
And the cap is 30.
the cap is 30.
And they say in their reply brief that you're treating them like an ATM.
Yeah,
But you disagree. I
I
understand.
understand they feel aggrieved and that they feel like the EPA has been has been, really working this particular site very hard. I understand the frustration. Amatec feels the frustration too. It's not like we want to be doing this either, but we have to because we have a consent decree from the EPA that orders us to do it. So the way the indemnity cap works is actually much simpler than you might otherwise think, and you only have to look at a few different clauses of the contract. The Goldfarb's argument is that the indemnity cap should be hit when what Amatec pays to third parties reaches $30 million, not what not when the Goldfarb's pay to Amatec reaches $30 million. The entirety of that argument rests on a misrepresentation of the definition of loss in the contract. It's quite clear. In 11.4 of the agreement, the way the cap works is it specifically says that no seller shall be required to provide indemnification to the company or any buyer entity under this agreement once the amount of losses paid by sellers equals $30 million. If it worked the way the Goldfarb said, then it would have to say losses paid by buyer equals $30 million. That's not what it says. It's talking about losses paid by sellers. Sellers are the Goldfarbs. So the only way that their argument works, they try to put everything onto the definition of losses, and the way they do that is if you see in their briefs, using ellipses creatively, they redefine losses to mean costs paid to third parties. But that is not what the definition of losses is under the contract. The definition of losses is any action, cost, damage, disbursement of any kind, including but not limited to interest or other carrying costs, penalties,
You
reasonable.
do a
concessions
very good
to
job in your
parties.
brief unpacking all of that, counsel. Is there anything else you want to say?
No, other than that, if the court needs to reach this, the court should find that the indemnity cap is determined by the Goldfarb's payments, and that summary judgment should be affirmed. Thank you.
Thank you, counsel.
Couple of quick points. The contention, first, I think that what you just heard only proves that there are issues for trial here, characterizing what these emails said and what they mean. The same thing with the documents that were supplied or were cited by the court in opposition and were led to discard the moving affidavit. Counsel said, well, you can, on its face, as a matter of law, in response to Your Honor's question, you can determine it and just disregard the affidavit. I suppose if an affidavit says, the moon is made of green cheese or something equivalent, you can disregard it. But that is not our situation here.
Well, except they said that the affidavit essentially said, no one ever told me this, but there are many, many emails in the record where Amatec gave him information about the very things that he claimed to have no notice of.
No, wait, there's a difference between giving them information and responding to the November 24 email, which they said they would respond to, and there's not a single document or testimony in the record that they ever said that they were going to reject the objections. That's in a totally different matter, and they've conflated them, okay?
So I asked you earlier on about whether or not Goldfarb had the right to reach out to the EPA directly, and that's in section 4.5. Is that not relevant to this particular argument?
It's relevant but not complete. It's not complete because unless you can participate with Amatec, you have no legal standing with the EPA. So it's a process where they would sit down with the EPA. The Goldfarbs would have the opportunity to speak with Amatec about what their position would be, what they might achieve in a negotiation with the EPA, but they were shut out of that process. So whether or not they could, under the agreement, speak to the EPA, that's like applauding with one hand. I mean, you have to be in a process with the contractual party that you're in privy with, and that was Amatec. Look, I want to take, if I might, with your permission, 30 seconds on the tax issue.
30 seconds.
Okay. So you start with record page 585. It defines loss as payable to third parties. That includes indemnities. That's with a capital L. Then you go to page 628 of the record, 11.5D, C rather. It talks about the tax adjustments that we referred to. which, with respect to a loss, the same capital L, takes into account the tax savings. That's what this paragraph says. But for the purposes of the cap, not how you calculate the individual payment, you go to the top of page 628. There's a subdivision B there, which says that it defines the $30 million cap, and there is not a single reference there to tax savings. It's not included in the calculation. It's when the amounts are paid, you reach $30 million. Under their interpretation of the agreement, the amount of indemnity might be, or the amounts paid could be $43 million deducted, then you're at 30. In other words,
Also, both sides do a very good job setting forth their interpretation of this section of the agreements. Thank you very much. Thank you both. People versus Charles Kenyatta. Please.
Good afternoon, Your Honors, and may it please the Court. Brandon Davis, a volunteer attorney from Lankler, Sifford, and Wohl, working with the Office of the Appellate Defender on behalf of Appellant Charles Kenyatta. I'd like to focus today on the conduct of the prosecutor in Mr. Kenyatta's trial. There were several instances where she crossed the line in her argument to the jury. On 6 separate occasions, she insinuated in her closing argument that Mr. Kenyatta had threatened people. These were the victim of the crime.
But there were corrective statements made by the court.
Yes,
with respect to several of those.
Yes, Your Honor. There were 2 curative instructions issued by the judge, but after each curative instruction, the prosecutor continued with her conduct. She made 6 statements insinuating that the victim, other bystanders, and even an actual witness were intimidated by Mr. Kenyatta. And these comments were objected to by trial counsel 4 separate times. The judge sustained the objection and issued short curative instructions that the prosecutor essentially ignored and talked over. A prosecutor's arguments are supposed to stay within the 4 walls of the evidence. And here, rather than harness her evidence, which was a video, she instead worked outside of those 4 walls and instead framed Mr. Kenyatta as somebody who threatened all of these bystanders and the victim of the crime, and that's why they couldn't testify. Now, the prosecutor argued that she is entitled to do this because Mr. Kenyatta opened the door to this kind of argument in his own closing argument, where he belabored the point that there was no testimony from the victim or the bystander. But a defendant is entitled to call the prosecution's evidence weak, and a defendant is entitled to highlight the weaknesses of that argument.
And the prosecutor is entitled to respond to that.
Of course.
And where the prosecutor goes beyond that and there's an objection, it's either sustained or overruled and a curative instruction is given, which is what happened in this case.
Of course. The curative instruction was issued and 4 separate objections were made and sustained, and yet the prosecutor continued her comments after every curative instruction, essentially mooting whatever impact.
Were there other objections made to those statements?
There was no specific objection to the curative instruction, no.
No, you said that the prosecutor continued to make objectionable statements. Were there objections made to those?
To those statements after the curative instruction. Whether there were or were not, this court would still have interest of justice jurisdiction given the pervasive conduct here by the prosecutor.
Counsel, even if we were to accept your argument, why wouldn't it be harmless error, given all the other overwhelming evidence in this case?
I don't think that this can be harmless error because these were the last words heard by the jury before the judge's charge.
Always determined to be arguments and not evidence in the case, and the jurors were advised of that.
The jurors were advised of that, and yet the last words that they heard right before they went to deliberate were that Mr. Kenyatta is to blame for the lack of testimony in this case.
The last word would have been something in the charge saying that the summations were not evidence.
Right, the last words would have been that, and yet the prosecutor still has a duty to not frame Mr. Kenyatta as an individual who's threatening various witnesses to this crime, and there's no evidence whatsoever that he did that. I'd like to focus on one other aspect, which is that the record also indicates that as the victim in this case entered the hospital, he was on the phone with somebody right as he was, he's shot in the leg, he's bleeding, and he's in an argument with somebody named Tommy right before he's getting shot. And the grand jury, the prosecutor never introduced this fact to the grand jury.
The hearsay information?
This could be hearsay, but I think that there's also an argument that this would be an excited utterance. He's entering the hospital, bleeding from his leg, talking about getting into an argument with somebody
So
named
if
Tommy.
we unpack the exception regarding excited utterance, right?
Sure.
The person has to be under the stress of the event,
Right.
right?
Uh-huh.
And he was shot sometime before he's walking into the hospital.
I think that the time record indicates he was shot maybe 10 minutes before he entered the hospital, according to the prosecution's case. And so we're talking about a very small amount of time, and a person is about to walk into an emergency room bleeding from the leg. I think there's an argument there that this could be an excited utterance, and I think that the grand jury should be entitled to hear this and
But
make determinations
that,
about the investigation.
okay, even if we agree with you, I mean, this is a very heavy lift. The impairment of grand jury proceedings, that's an exceptional remedy,
Of course,
right?
yes.
So how does it reach that threshold?
I think that regardless of the prosecution's evidence and regardless of the outcome in this trial, a criminal defendant is still entitled to have a fair and impartial grand jury process. And were this kind of evidence heard, maybe the grand jury wants to take steps like call the person who Mr. Allen is on the phone with. Maybe, I believe he was on the phone with his mother, who the police were able to interview. Maybe if they presented this evidence to the grand jury would have taken the opportunity to call his mother. I'd like to close by just saying that I understand that the evidence in this case is a video, but I'm not sure that the video necessarily is as strong as the prosecution makes it seem. And even if it were, she should have stayed within the confines of the evidence in this case, which was that video footage, rather than make these comments to the jury, rather than withhold arguably a complete defense from the grand jury, which would have given Mr. Kenyatta a much more fair shake in his trial.
Okay, thank you, counsel. You have time in rebuttal.
Good afternoon, Your Honors. My name is Patricia Curran, and I represent the people on this appeal.
Can we start with that last, statement of this complete defense regarding this argument that was allegedly had with someone named Tommy as the complaining witness is walking into the hospital?
The prosecutor was not required to present that evidence to the grand jury. First of all, as Your Honor pointed out, it was inadmissible hearsay. It was a comment by the victim who did not testify in the grand jury, overheard by a hospital security guard.
Isn't it potentially exculpatory? Doesn't the prosecutor have some obligation on that level?
I'm sorry, Your Honor, I missed the first part of your question.
Isn't it potentially exculpatory, excuse me?
Well, Your Honor, this evidence wasn't exculpatory. The grand jury saw the video, which clearly showed this defendant shooting an unarmed man at close range. There was no doubt of his identity because the still photographs were introduced into evidence, as well as the photograph of the defendant's Instagram account, which showed not only his face, but his distinctive jewelry that he wore and he was wearing at the time of his arrest. Even if the victim had had an argument with Tommy, there was no indication that Tommy had shot him, particularly because of the overwhelming evidence of the defendant's guilt of the shooting.
What about these comments that were continuously made during closing arguments?
Well, Your Honor, the counsel today said there were 6. I counted 7 that he is now challenging, none of which were preserved. There were several that were made only general objections, 2 that were sustained, and 2 where there was no protest at all.
And what about counsel's statement that the prosecutor continued or repeated the conduct after having been told not to?
There were 2 comments at the end of her summation where the prosecutor continued after the judge had made the curative instruction. The records suggest that she continued because she thought perhaps the court had misunderstood that she was actually making a record-based argument. In fact, she points out that she is making the argument based on the video. Now, would we have preferred she had stopped? Yes, and if the court is concerned about that, I would point out that there's simply not an egregious or pervasive attempt here by the prosecutor, and as I think the court pointed out, anything that she said was harmless.
When we talk about pervasive, if you have objections that are being made and a prosecutor continues to make this objectionable commentary after these objections have been made and sustained,
well, Your Honor,
could that not rise to the level of being pervasive?
No, Your Honor. These comments, all of them, were made at the end of a 37-some-page summation, and as we pointed out in our brief, the defense arguments on summation repeatedly argued that the reason that the victim and any of the witnesses had not come and testified or even come forward and called 911 was because the defendant had not committed this crime. The prosecutor never
But
argued.
that's the defendant's right? To make arguments regarding the weakness of the case.
Of course, but the prosecutor is entitled to respond because the defendant said there was no evidence of any other reason why they hadn't come forward except for the defendant's innocence. But there was evidence of that. The bold, brazen violence of the shooting in broad daylight in front of witnesses, a number of whom obviously knew the defendant, including the victim, would have intimidated people from coming forward. The prosecutor never argued that this defendant had gone out and specifically performed threatening behavior to any of the witnesses, to the shooting victim, or any of the people on the block. That's different than what she argued. She argued that the boldness and brazenness and violence of what happened intimidated people from coming forward. And that was fair response to what the defendant argued repeatedly during his summation. I see that my time is almost up. If anyone has other questions about any of the other points, I'd be glad to answer them, or anything about the summation comment. Seeing none, we rest.
Thank you, counsel.
Thank you.
Your Honors, I just have two quick points I'd like to make. Counsel just said that these are comments that the prosecutor should not have made. 7 instances, I think, constitutes pervasive. She went beyond the judge's curative instructions. She went beyond the sustained objections. There is no evidence that Mr. Kenyatta knew any of those bystanders because none of those bystanders testified. None of them were interviewed by the police. And so to insinuate that, I think the words out of the prosecutor were something along the lines of that Mr. Kenyatta would know where they live. To insinuate that they would face violence were they to cooperate and talk to law enforcement, I think certainly constitutes the kind of misconduct that shouldn't be allowed. And our brief cites a litany of cases where far less conduct by prosecutors around the country have resulted in new trials when they were made in this fashion. The other thing I just want to touch on is that even if this video was so clear and even if the evidence was so overwhelming, Mr. Kenyatta still has due process rights. He still has rights to a fair trial, and he still has rights to a trial in which the prosecutor is not permitted to make all of these comments insinuating that he is to blame for the lack of any testimony from the bystanders.
It sounds the way that the prosecutor just argued was that not that he was to blame, but the nature of what happened is to blame for why people might be unwilling to come forward.
I understand, and there's actually a case that they cited, I believe, is Macaulay, where I think it's the second department is okay with prosecutorial comments that relate to the shooting, the actual crime that the trial is for. But when those comments go more towards the future and say that, you know, the victim is afraid of what would happen to him if he came and testified, the bystanders to the crime are afraid of what would happen to them if they, in the future. It's not only the act of violence that allegedly happened, it's a future threat, and that's what makes these comments so pervasive and so damning that they were the last thing that the jury heard before going in to deliberate. Thank you.
Counsel, you took on this appeal pro bono?
Yes.
Thank you very much for doing that.
Thank you for the opportunity to be heard.
People versus Anthony Messina. Please.
Good afternoon, and may it please the court, Jacqueline Shelton for the appellant. This appeal raises 3 critical issues about the Raise the Age Act, an act that was intended to revolutionize the way that New York treats children.
Counsel, could you address, with regard to the third case on which the defendant was indicted, thank you. In that case, it appears that defendant agreed to his retention. I didn't see anything in the record that would be a basis for disputing that he had agreed to the retention, although you ask us to somehow undo his consent. What basis is there in the record for us to dispute that he consented voluntarily and intentionally to the retention?
On the record that we have, which is quite sparse, this cannot be said to be a voluntary and intelligent waiver of his right to be considered for removal and right of review of the accusatory instrument.
Well, he answered the questions that the court asked in the way that would suggest that he understood what he was doing. What was faulty about the questioning?
Yes, so
And also, counsel, if you just kind of couch that in the fact that this was his third time at this type of procedure, meaning a retention.
So I'll address both issues in turn. I'll start first with, this was the second extraordinary circumstance motion, but the first case proceeded through a different procedure, which is the 6-day review for violent felonies.
All under the auspices of a retention, whether you stay in criminal court or you're removed to family court.
Yes, but I just point out that it was through different mechanisms. The statute does authorize a young person to waive their right for review. However, it is very careful to acknowledge and using language that it has to be a voluntary and intelligent waiver.
So if you could just tell us what is missing from that.
Okay, a lot. So there is a misstatement of the law as I was reviewing the transcript again. First, there's no reference to family court at all by the motions judge. There's also the way that the court describes this, the attorney says that he is not going to file an opposition. And then when Anthony appears in court with counsel on the next appearance, that decision by counsel to not file an opposition morphs into consent. And the judge says, well, I received this email and it's my understanding that you're consenting.
Well, it's not that it morphs, it's clarified, right? If you're not filing an opposition to this retention hearing, what are you doing? Are you consenting to it?
And the court further says he either has to consent or I'm going to give you another date to respond. And then they go through the actual allocution, if you will.
So what's missing here is there is a presumption of removal for this type of charge and this type of case. So there's no explanation that it's on the prosecution to establish that the case shouldn't be removed.
But is there any case law supporting what kind of questioning a court has to do? The counsel didn't object to the question. Counsel seemed to have had the conversation with his client. Why isn't that good enough?
This is a matter of first impression, so there is not case law on it. But this is a personal right, and similar to a very important right, such as waiver of the right to appeal. It has to be the court that establishes a knowing and intelligent waiver. So here, there's no written waiver that we would see for adults in a waiver of appeal for Anthony to review what rights he is giving up. There's no explanation of this huge difference between treatment in family court versus treatment in adult court. It means the difference between a violent felony conviction and potentially decades in prison versus no criminal record and adjudication through family court. So it is an incredibly important right for the most vulnerable members of society, and it is a motion that the prosecution bears the burden of proving. It's not on Anthony to dispute. The court has to make this determination that the prosecution has established their burden.
Counsel didn't object to the procedure or the questioning, correct?
Counsel did not, but it is a personal right, and we know that from the statute because it says that the individual is allowed to waive it, but it's not something that counsel is able to waive on behalf of another person. So yes, counsel did not object, but it is on the court to ensure a record that shows that this was a knowing and intelligent waiver of his right to be considered to treatment in family court, which does tie into, I want to address the first case here, which is—
Before we get to go back to the first case, I have a question about the implications of the third case. In your brief, in a footnote in your brief and another footnote in your reply brief, you state that if we determine that any of the cases should have been retained, that your request is that we retain them all in Supreme Court and not vacate any. Is that still your position?
Yes, and that is because the goal for Anthony, after considering this, is to not have these acts that occurred when he was a teenager define the rest of his life. So we want all of them to be removed. If the court finds that one or more are not to be removed, it's our request to proceed to youthful offender consideration, or at a minimum, reduction of the post-release supervision.
So you would want them to remain in Supreme Court for that purpose?
If we believe that all
If you can't
three,
get the removal,
yes.
if you can't get the removal of 1, 2, or all 3 preferably,
Yes.
if 1 or 2 remain in Supreme Court for the purposes that you just explained, then you would want to pursue that in Supreme Court, right?
All
Yes,
three?
because youthful offender adjudication could address some of the longevity of these impacts on his life.
Regarding a youthful offender adjudication, I thought that that was already denied in the Supreme Court. And that you were requesting for this court to review that.
That's correct.
Okay.
So we are asking, if the court disagrees with us on one or all, we are asking this court to exercise its discretion in granting youthful offender as to all 3 of the matters.
Right, so it wouldn't be, the youthful offender adjudication issue wouldn't be the thing that the case was sent back to Supreme Court for, right?
Correct. Yes, this court would be able to address the issue.
But you wouldn't want us to address that, you would want us to only grant it if we sent one case we said one case should have been removed. You would want us, if we granted it, then keep the case at the status quo? I'm just trying to unpack what you're asking.
Yes, and it is a bit complex with the 3. So if, let's say there's 2 that the court says should have been removed, but 1 no.
Right.
And we're just asking to keep things status quo, but review youthful offender adjudication as to all 3 of the cases.
Oh, as to all 3, yes. Okay.
So a remand to the Supreme Court to consider youthful offender status.
No, you want us to consider
Yes.
it, because it was already considered.
Yes, so
okay,
we would
thank you.
ask the court to exercise its discretion to grant youthful offender adjudication.
Understood. Thank you. You have time to rebuttal, counsel.
Okay.
May it please the court, Amanda Regan on behalf of the people. Starting with the waiver issue, as provided in CPL 72223 sub 4, a defendant may waive removal of his case to family court so long as the waiver is knowing, intelligent, and voluntary. And here the record clearly demonstrates that this was a knowing, intelligent, and voluntary waiver.
Well, counsel, I mean, to be fair, in the record, the court says the case will remain here in Supreme Court with me, but it never says what the alternative to that is. It never explains why that's important. Is that necessary for it to be knowing and intelligent and voluntary?
In this case, no, because this was defendant's 3rd case where it had been previously litigated at a 6-day retention hearing and then an extraordinary circumstances motion. So this defendant in particular was familiar with what his options were in terms of having a case be retained in the youth part of Supreme Court, and he even had 2 other cases that had been removed to family court. And so he was intimately familiar with both options.
Court, right? Those 2 other removed cases are sealed matters that shouldn't be before this court.
I believe that the statute that my adversary cites, Family Court Act 381.2, is not applicable here because that act is, or that statute rather, is discussing confessions or admissions or statements made by a defendant. Here, this was actually all part of the record. I believe it was at pages 6 and 9 of our extraordinary circumstances motion in the 2nd indictment, and then at pages 5 and 6 of the extraordinary circumstances motion in our the 3rd indictment, where we referenced the fact that there were these 2 cases that were removed to family court, and the extent of what we said about it was that it was for theft of an automobile. That was it. So we didn't go into anything that would be sealed because it wasn't the defendant's own statement. That information is discernible just from the nature of the charged crime.
And you raise that as an aggravating factor as to why that case should have remained under extraordinary circumstances?
I think it's one of the aggravating factors that could be considered because it shows that this defendant who was engaged both with the services of cases and the Esperanza program through the youth part and through the cases that were removed to family court, presumably was engaged with services in family court, that he wasn't amenable to those services.
I'm curious about what you mean by amenable, because the record, as I read it, is that he did all the things he was supposed to do according to the programs.
When you say amenable, do you mean that it had an impact on keeping him out of being involved in alleged criminal activity? Is that what you mean by
Yes,
amenable?
here he is continuing, despite these services that are being provided to him, he's continuing to commit further crimes, and not only just further crimes, but escalating crimes in terms of the violence.
So when you say amenable, you're not meaning that he was rejecting it or didn't want to participate in the programs. He was participating, right?
We have limited information, but the information we do have is, yes, that he was participating in the programming, but that the programming was not serving its intended purpose, which was to assist him in turning his life around away from future crime.
So if the programs take the position that he was doing all the things he was supposed to do, but it didn't prevent him from committing further crimes, maybe the problem is with the program and not with him. Is that a possibility that you would consider?
Perhaps, Your Honor, but I think the question here to come back to in terms of the second and third indictments is whether the judge who was in the best position, best suited to determine based on the specific circumstances and factors of this individual defendant, whether there were extraordinary circumstances that warranted retaining the cases in.
How do we define extraordinary circumstances?
I think here the statute does not define what extraordinary circumstances are, but I think if we're looking at the plain, ordinary dictionary definition of extraordinary, I think that is something that's not customary or out of the ordinary, and the judge is in the best position, the judge and youth part is in the best position to make that determination.
So the judge and the youth part is in best position to evaluate whether the conduct that is the subject of the extraordinary circumstances motion is unusual compared to other cases in the youth part.
Yes, they have to look at the individual circumstances of each defendant that is before them and decide based on the specific facts and circumstances relevant to that person, whether or not it constitutes an extraordinary circumstance to retain the case. And here, I think it's clear that there were extraordinary circumstances. This defendant was committing escalating acts of violence. In the first instance, the first indictment was a violent, vicious gang assault where the victim was stabbed. The second one involved a gunpoint robbery that defendant helped facilitate. And then the third one, the defendant himself was actually armed. And the only reason that case was not retained under 722.23 subsection 2C Romanet 3, Romanet 2, I apologize, is because we did not test the gun for operability. Otherwise, that would have been retained.
I thought in the record, it wasn't clear that he was holding a gun or something that was thought to be a gun. I didn't see
because we
anything
didn't
that went
prove
beyond that.
operability. It was because we didn't have the gun tested for operability. But had we had that tested and established that it was an operable gun, presumably it could have been and would have been retained under CPL 722.23 2C Romanet 3.
So I have two other questions about extraordinary circumstances. It seems to me that under the legislative history, to the extent that it exists, suggests that extraordinary circumstances should be something that happens 1 in 1,000 cases. Is that typical of what's, is that how the judges are interpreting it, or is that something different? And my other question is, all of these events occurred during the pandemic for a young man who apparently had a lot of difficulty with self-regulation because of learning disabilities and so on. So that one might think that the pandemic, with the change in structure available to him, would have had a major impact. Is there any indication that either the defense argued that and/or that the court considered that as a factor?
No, in fact, in the second indictment extraordinary circumstances motion, all of the mitigating circumstances that defendant now seeks to raise on appeal were not before the judge. And so those arguments are all unpreserved. I believe many of the factors that were raised were reported in the cases report, and so the judge was aware of the difficulties that the defendant was facing at the time. But the reality is all children in New York were facing the same difficulties during the pandemic, and many of them were not committing an escalating pattern of violent crimes, whereas this defendant was. And so here, the judge was fully within the bounds of the statute in finding that there were extraordinary circumstances. And I would like to just briefly, because my light is on, address the accomplice liability issue under the first indictment. The plain language of the statute, I see my light is on.
Please go on.
Thank you, Your Honor. The plain language of the statute permits the court to consider when the defendant causes significant physical injury. Defendant tries to insert both sole and direct cause into that definition, but the plain language of the statute is unambiguous, and neither.
Is there anything in the legislative history that would indicate that because this is happening in now this raise the age context that we should look at accomplice liability different than how we look at it in I don't know, adult court?
Normal criminal context.
No, thank you.
I think in this context for accomplice liability in particular, because the statute is unambiguous and we can just look at the plain language of the statute, the legislative history has even more limited purpose. There is a comment made by the bill sponsor that it's intended to apply to sole actors, but I think that off-the-hand remark is not applicable, especially under the facts and circumstances of this case, where during a 5-on-1 assault where defendant and his cohorts all attacked the victim simultaneously, and we were not able to discern which of the 5 actually was the one who pulled out the knife and stabbed the victim in the left side. And defendant was specifically seen punching and kicking the victim while he was lying on the ground, at a minimum aiding whoever the stabber was in attacking this vulnerable victim. I think here it's very clear under these facts and circumstances that accomplice liability was properly applied.
Under the penal, go ahead.
So the legislative history also uses the phrase that it was only to disqualify from being sent to family court the individual who, quote, directly caused the injury. So that seems to me another element that the court might consider. And you didn't really address the issue I raised about extraordinary circumstances properly being only applied in 1 of 1,000 cases. Is that
Yes, Your
consonant
Honor.
with your
I think
experience in the youth part?
I think that is certainly a consideration. Obviously, the goal of Raise the Age was to remove a number of cases, but when the facts and circumstances rise to the level that they do here, all 3 of these cases were properly retained in the youth part. I think that the level of violence that was exhibited in all 3 cases and that this was an escalating pattern demonstrates that there were extraordinary circumstances. And addressing the accomplice liability, again, the legislative history here is not necessary to determine the question of causation because the statute is unambiguous. And the plain language of the statute says defendant causes significant
So how about
injury.
the backdrop of criminal law generally? So under the penal law, is a distinction drawn between, for criminal liability purposes, the actions of the direct perpetrator on the one hand and an accomplice on the other?
No, and there's no carve-out in the Raise the Age statute that says penal law section 20 does not apply or does apply. And I think other sections of the juvenile offender statute are illustrative here because in that subsection or that statute, there is specifically a carve-out to remove cases where the defendant is the sole actor. And that same carve-out does not exist in the adolescent offender section of the Raise the Age statute.
I noticed that the retention court used the phrase that there was a community of purpose to describe the actions of the defendants in the first case. Does that appear elsewhere in the criminal law? Where does that phrase come from?
I believe there, although there's no appellate case law, that is a phrase that's coming from emerging trial court level case law, that where defendants are acting with a community of purpose, where, such as here, where they're all acting together in
But it doesn't come from anywhere else in the criminal law.
As far as I'm aware, no.
Isn't that just acting in concert?
Basically.
Yes, essentially, yes.
It's just an inartful way of saying acting in concert.
Exactly, Your Honor.
Thank you.
Unless Your Honors have any other questions, we'd ask that you affirm.
Any other questions? Okay, thank you. Counsel, I'll give you a little extra time on rebuttal.
Just three quick things. I know there's a lot to address here. First, the cases referenced by the people are and have been sealed. So it's not only the Family Court Act, but it's also 72225 that prevents their consideration in a criminal public court setting. So they were improperly considered as part of the extraordinary circumstances motion. To get to the waiver issue, which also sort of encompasses the mitigating circumstances here, it is also relevant when we're considering this waiver that we do have in the record and what was before the motions court that Anthony was a special education student, that he, all of this information was contained within the cases report, which talks about him being despite this, being very committed to his studies. He's teaching himself, on a laptop at home without his support system that he's entitled to for his disability. He's described as very
One of the questions that was raised regarding the programming is that if he wasn't doing well with the programming or he was still picking up cases while he was in the programming, maybe there was an issue with the programming, right? So if we look at it from that vantage point, what import does what you bring to the table about what the program had to say really serve?
So the difference here is this is an alternative to detention in adult court, which went on for 10 months while he was languishing, waiting for the case to proceed, versus what he could have received in family court, which is much more.
Why are we using that adjective languishing, right, when he was receiving services during that time through a program that many individuals in that court part receive services through, right?
Yes, I'm drawing the distinction between the length of time and the intensity and specificity that a youth would receive in the youth part versus family court. So in family court, a person such as Anthony would be adjudicated very quickly, within 30 days, if he was detained, and there could be out-of-home placement services for him. So he would undergo a very intense psychological evaluation. There would be interviews with his family, school, all of these different things, and to find the appropriate program. Not saying that that program, is not the appropriate fit for many other young people, but for Anthony, who had had these needs, family court would have been more appropriate for him to be adjudicated in.
Counsel, recently the Fourth Department decided a case, People v. Guerrero, kind of touches on the issue of extraordinary circumstances and talks about it being a totality of the circumstances. In that particular case, there was also a juvenile delinquency adjudication that, yes, were sealed, but underlying facts of how this that particular defendant interacted with the services was the totality that the court could look at, so that there was no extraordinary circumstance for which,
Yes.
well, there was extraordinary circumstance for which it should not be removed.
Yes.
Are you familiar with that case?
Yes, Guerrero is interesting, but the distinction is that youth was found adjudicated or found guilty in family court and received services, whereas Anthony had not. Just extremely briefly, so we are not seeking to add anything to the way that the legislature crafted 72223. The people's argument asked to incorporate something from the penal law, 20.00, accomplice liability, allowing for an individual to be held culpable for the actions of another, into a statute where it wasn't written. And this is a different beast, essentially. This is not about whether he could be found guilty or culpable. That can still be determined in family court. This is a preliminary procedure with a higher burden of preponderance rather than what an indictment would require. There's language crafted out, significant physical injury, that we don't see anywhere else in the penal law. It's something that happens very quickly, 6 days. It's a procedure preliminarily to determine whether the prosecutor has overcome the burden of a presumption of removal. And
But
it
we have
was-
to assume that the legislature is fully familiar with the state of the law when they act.
Yes.
And so if the state of the law, and if I'm wrong on the state of the law, you correct me. My understanding of the state of the law is, at least under People versus Rivera, for the purposes of criminal liability, we don't draw a distinction between the actions of a direct perpetrator and the actions of an accomplice. And that's, I guess, Penal Law 20?
20.00, yes.
So if we do have to assume that the legislature is fully aware of our body of law when they legislate, if they wanted to disturb that normal understanding, wouldn't it have been a simple matter to define the term caused in a unique way, or somehow make it clear they were only talking about the actions of one who directly caused one of the enumerated events?
So, caused is within the existing state of the law as well. And the difference is the criminal procedure law, there are references within Raise the Age that talk about this part of the law applies to the penal law for adolescent and juvenile offenders, but it's not the inverse. So we know that the legislature knew how to do this, and they could have done it. They could have referenced 20.00 also applies, but this is a separate law. This is the criminal procedure law rather than penal law culpability. And had the legislature intended to do so, they could have. And we also see replete throughout the assembly debate reference to kids get in trouble all of the time together. We know from Supreme Court existing case law that peer pressure is much more significant on behavior for kids than adults. And there's this discussion throughout the assembly debate about this sole actor. Perhaps not the best choice of words, but it's clear the intent here is to look at the individual. I think one of the legislators even said, the idea here is to look at the individual. And
if we look at the individual and we bring it back to your case, right? Anthony was involved in punching and kicking this victim, and as other people were also doing things. So that's an active participant.
Active participant, bad conduct, yes, as to kicking and punching, 100%. But other cases, even if the court were to consider acting in concert, he does not have the shared intent of an individual who engages in a group fight with a weapon. And there are other cases decided by this court, Yuri Wilson, matter of People versus Raheem Campbell, that talk about this. You can engage in a gang assault, as I said, kicking and punching, but there is no evidence here to support that there was the foreseeable consequence of kicking and punching would result in this stab wound and that another individual had a knife. If there was open display, if there was any evidence before the court below that he was aware that another individual had this weapon, that would be something different. But even under a very broad idea and notion of acting in concert, or even a broad notion of causation, which we know is a higher level than civil cases, given what we have here, which is just the felony youth complaint and the medical records, there's nothing in the record to indicate that he knew that one of those individuals had a weapon and was choosing to engage in the fight with a weapon, which resulted in that significant physical injury.
Thank you both.
Thank you.